Welcome to Talk Lex, a podcast dedicated to common sense discussion of legal issues facing everyday people. Brought to you by DeRazio Peterson. For more information, visit DeRazioPeterson.com. Welcome to another episode of Talk Lex. I'm Scott Peterson. I'm here today with Kevin O'Brien, who's the founding member of O'Brien and Eggleston, which is a criminal defense law firm in Albany. Kevin is a fellow Albany Law alumni, but he's someone that I would describe as an in the trenches criminal defense lawyer, meaning he's actively trying cases in a courtroom. And I thought that he'd be helpful to have on the podcast to kind of talk about some of the basics of the world of criminal defense that the average person probably wonders about, but doesn't really have any insight into. And I'll be very honest and say that in my almost 20 years of practicing law, I found that a very small number of criminal cases, and those that I did were very, very low key. So I do not have a lot of understanding even of what the criminal world looks like these days on an inside baseball kind of basis, other than, some of the classes that I took back in law school. So I think this would be an interesting conversation for me too. So Kevin, thanks for coming on. I appreciate you being here with us today. Why don't you give us a little bit of your background and kind of tell us how you ending up in criminal law?
Well, first of all, thanks for having me. And I guess the reason I ended up in criminal law, I actually kind of always wanted to be a criminal defense attorney. I thought that was kind of the most interesting area for me. And frankly, as a young guy, I got in a little bit of trouble myself and wouldn't have minded having somebody who I felt was similar to me defending me. So I kind of get the luxury of doing that now. I tell a lot of my clients that I'm a little bit of luck and a few bad decisions away from being them. So I think that helps with relating to them. And I've been doing criminal defense. I guess you just broke my heart when you said almost 20 years, but you're right. I got out of law school. I went to a civil firm for a very short period of time. Then I did criminal defense for about a year, realized that nobody trusted me because I didn't know what the hell I was doing. And so I went to a DA's office for about 3 years. And since 2010, I've really been active in doing criminal defense. And frankly, I think, probably have as many or more trials than most people our age anyway, in this particular field.
Yeah, it's interesting that you talk about your experience as a kid. I remember when I was in college and, friends would periodically get into trouble. And I went to a school in a small town and there was like one lawyer. And I always got the impression that the criminal defense guy up there, wasn't really doing a whole lot to help the kids out. It was kind of a rubber stamp. Here's what to expect. And so was that your experience when you had those issues as a kid, or did you see what was the representation you got and think this is how I want to do it, or was it the opposite and you thought there's got to be a better way to help young people?
Well, it's funny. I grew up in a small town myself, and there were only 2, maybe 3 lawyers, something like that, at least the ones that I knew. And I think it was similar to your experience. Like the way that I classify criminal defense attorneys is kind of, there are the guys, kind of just, they'll charge you $1,500 no matter what you did. And they go in and they ask for a plea, and whatever the plea offer is, that's what you're going to take. And, we're, I guess, competing against them. And then there are, kind of just crappy criminal defense lawyers who think they're good at it. And then I think, there's the upper echelon guys. I guess it's not very humble, but I would put myself in that category. And there are a handful of them in the area. And we kind of get in there and kind of get in the mix and really litigate these cases and often try them. So I was fortunate. The only time I really had to go to court, I had a very good defense attorney. I didn't know what I didn't know. So, he was very generous and helped me out being an Albany Law guy. I got a DWI my first year in law school. I think it was my first year. And, I was absolutely guilty. But at the end of the day, he helped me out a lot. And I thought he was pretty good. And I still know him to this day, which is kind of funny. He does things a bit differently than I do, but he's a very good attorney. So I was lucky in that regard.
Yeah, I was going to bring this up later, but since you mentioned it, I think it's an interesting point to discuss now. You talk about how there's sort of these different approaches to lawyers who practice, and we see that in our world, right? We do quite a bit of personal injury litigation, and we have like a small practice, and we litigate cases pretty thoroughly, and we often we'll take them to trial. And there's obviously a very different approach of some other firms where it's just a sort of churn them and burn them mentality. And clients come in and it's the same approach, and it's what's the quickest number we can get. Let's settle it and get it out the door. How do you distinguish yourself? Because you kind of mentioned it, the average person walking down the street has no idea whether you're, lawyer type A or type B, and frankly, whether it's the right approach for them. I mean, what do you do, and how do you kind of try to show people that your way of doing things is potentially more beneficial when they're accused of like serious crimes?
I guess the best way I can do it, I hate the way that lawyers are allowed to advertise in New York, because I think it gives them, you hear things like, the DWI guys or DWI Tom or something like that. And it has no real substance to it, but they're allowed to do that. But if you start putting substance to it, then you get in trouble, because you're talking about results and you're talking about things that would potentially lead a client into believing that you're guaranteeing them a result, which I don't agree with at all. I think it's silly, because I think when you say things like, the heavy hitters or, DWI Tom or whatever, you're saying something similar without any substance, but the average person is going to be like, oh my God, that guy must do a ton and he must be great. They call him DWI Tom or whatever you want to call it. So the way that we approach it, I try to get people to meet with me in person if they will. And I think that that's the best way to do it. And I think even if they choose not to hire me, I think it's the best way to do it, because what I tell them, I said, I'm not a hard sell guy. Like, of course I'd like the business. But I want, and I truly do believe this, it sounds like lip service, but I want you to be most comfortable with whoever you hire. I'm going to be more expensive than some guys, most guys probably, and probably less expensive than some of the older guys who have been doing it a little bit longer and have maybe a stronger reputation, even though, in my opinion, I don't think they're doing anything better, but they've earned that reputation. So I tell them, if you want a quick plea, you should hire the guy that's, $1,500. But if you want somebody to really look at your case and really look at what your goals are and how they work for you or your family or whoever it may be that you're most concerned about, then I think you need to hire somebody who knows what they're doing. And that could be me. It could be a host of other people in Albany. I don't think I'm the only guy that's any good. I think my partner's great. I think I could probably list off 10 or 15 guys that I think are really, really good. But I said, if you sit down and you're most comfortable with me, you should figure out the money. And I understand, growing up a poor kid in the middle of nowhere, that most of my life I wouldn't have been able to afford me. But I think if you can, you want to have somebody that you really kind of, I hate to use the word vibe, but you vibe with, and you feel like you're going into a potential battle together. And it often can be, because when we walk into a courtroom, I tell my client, there's the beautiful thing that said, the presumption of innocence, but there's not a damn person in the courtroom who doesn't think you did something, other than maybe me and you, and maybe your family if you brought them along. Everybody else, you walk in and they say, what did he do? That is the first question. So for me, I think you want to set real goals with your clients, and I think you want to have personal, but an intimate relationship with them in the sense that you're going to be going to war for them. And if you know what they want and you can adopt their goals, then they should feel comfortable with that. And I tell everybody, I'm not perfect. I don't win every case or anything like that, but I will promise that I'm going to go in and I'm going to do everything I can to try to help you out and get you to the result that you need. And we even talk about, goals. Like, a lot of lawyers will say, well, I think we can get here. Well, I want to know what their goals are as a person. Like, are they trying to move in the next year? Is their kid going to college and they need this to be done, or whatever the case may be? They're looking for a new job, or, they're going through a divorce. How does that impact you? And it doesn't necessarily have to be a legal thing. You can tell me what your goals are, and then I can try to work it into the case legally as much as possible.
Yeah, I think we take a similar approach on our end. I think two different people with similar situations but different desired outcomes that can lead to a very different approach in terms of the timing and your overall position in the case. So I completely agree with that. You mentioned something that got me thinking about doing PI or personal injury work. We'll occasionally run into people and they'll sort of joke about it. And part of the reason they joke about it is, I think, some of the advertising that you were mentioning before, but they'll say things to us like, oh, how's it feel being an ambulance chaser? Or, some comment about sort of degrading what we do. I wouldn't imagine you get that, but what I would imagine is that from time to time, you get some questions along the lines of, how can you defend someone like that? Or how can you sleep at night doing what you do? Do you ever get those kind of questions? And what's your philosophy about the kind of work that you do? Because obviously you are occasionally involved with clients who are accused of pretty bad things.
Yeah, I mean, and I think you hit it on the head there. Like, you guys are called ambulance chasers, and and I don't agree with that in any sense, because I think what you guys do is incredibly important. I just don't know how to do it, and frankly, I think if you can, you should focus on one area. But the thing that you said to me was exactly what everybody asks, and it's funny because I'm always happy to discuss it with people, because I want them to understand as best that they can. And I think, generally speaking, I'm a good guy. So I want them to understand that I do it because I really believe in it. And it matters very little to me whether my client is guilty or innocent. I think if the government can't prove them guilty beyond a reasonable doubt, then the government shouldn't be charging them, and they should do a better job either investigating the case, charging the case, or gathering evidence. And a lot of people are surprised to hear, I'll tell them, the clients that drive me the most crazy and make me, lose sleep and almost I don't like them are the clients I truly believe are innocent, because that's a heavy burden that we carry. And I know from doing this a long time that those people, not often, but can get convicted of something they didn't do. And I just had a rape trial recently, and it was a rape one. The victim was alleged to be, I guess the alleged victim was underage at the time, and it was a forcible rape situation. And I looked at this case. I got into it late. They hired me basically just for trial. But I looked at the case and I was like, this guy is innocent. I was like, he's innocent by the law. And I also believe he's actually innocent. And those cases drive me crazy, because as much as I believed it, I was very, very worried about a conviction. Ultimately, there was no conviction, and that was great. But even then, what we do is so important, because that guy's life does not go back to normal. I'm not going to give too much information about it because I don't want to make it worse for him, but he's in a relatively small area. There's a certain amount of people that are always going to believe he did it. And there's a certain amount of people who would have never believed he did it, but he owns a business. He does good work. His father had a business before him. So they had a great reputation. And the father was really broken up about it, because he was an old Italian guy. And he basically was like, I've been working my whole life to build my name, and they do this to my name. And it was a crazy case because the government just didn't do their job. They didn't talk to witnesses who were present at the place. You'd never believe it. They didn't even go into the business where it allegedly occurred. Never even walked inside. There were cameras in the business. There were, there were multiple witnesses, some of whom have worked in law enforcement and worked in security, and the investigator never even talked to them. The jurors came up to me afterwards and told me they had the decision on a really heavy case in 3 minutes, and then they spent the next 17 minutes just bitching about the government and how crappy they did in the case. So those are that's a long way of answering. I have no problem with what I do. The government has way more resources than even my richest clients. And if they can't prove it, they shouldn't be charged. And even if the person is guilty, do a better job.
I have to imagine that it's a 20-minute verdict, even if they spend 17 minutes griping about the government, that's got to be a quick verdict, right? I assume they're not usually coming in that quick, or is that normal?
No, they don't. It's strange though, because conventional wisdom, in my field at least, says that a quick verdict is a bad verdict. That has not been my experience. I don't get a ton of quick verdicts. I think most of the time the juries want to look at things, and most of the time they really want to hash things out and discuss them. But I think the quickest verdict I've ever had was, I didn't time it, but it was half a cigarette. I don't smoke, but my client did, and he was halfway through his first cigarette. We were standing outside, and the clerk of the court came outside, and she was like, "We've got a verdict." And I was like, "Oh man, this is either going to be incredibly embarrassing or incredibly awesome." And fortunately, it was awesome. So I think I've had about 3 or 4 verdicts that came in less than 30 minutes, but the half a cigarette one, I think, is going to probably stand the test of time.
Yeah, I've never had one that quick. But again, from in my world as a plaintiff's lawyer, if it comes in that quick, it's not good for me. So yeah, I typically like a little bit longer than that. I mentioned to you I would ask you a handful of questions that people sort of ask, the common layperson asks. And one of them I think is, do you have that conversation with clients? You said you don't care if they're guilty, and that makes sense to me logically, but is that a conversation that happens, or do you prefer to leave it open and kind of resort to the facts? And I don't want to put you in a position where you say something that you're not comfortable with, but people have asked me that, and I'm kind of curious about it myself.
I guess it's evolved over time. I used to ask them very specifically in the initial meeting what their recollection was, what they did, what they didn't do. And I'm less inclined to do that initially now. I want to find out what they remember, what they think is good for the case, what they think is bad for the case, ask them some questions. But most of the time I want our defense to evolve. And this is going to seem like I'm kind of suggesting to clients what the truth is. And I really only want them to tell the truth, because I think jurors are great at reading whether or not somebody's being forthcoming and genuine. But I do think you can massage the truth a little bit to make it sound better. So I don't want to know exactly, especially in the heat of the moment when they're really trying to decide what's going on. But eventually they almost all tell me one way or another. And, some of them will say they're innocent. I'm like, I don't believe you, even as your attorney. I'm going to represent the hell out of you, but I don't believe you. And that's okay. But some of them I really do believe in. And when they're so adamant about it, it's really a scary position to be in. When they are so convinced about being innocent. And I end up buying into that. It's a scary thing, but most of the time I ask them generally what happened and ask them to leave out the details. For example, like a DWI, I'm like, tell me what happened. Where were you? What were you doing? What were you drinking? But I don't want to know the number of drinks right away. I don't want to know when your last drink was necessarily. I want to be able to look at the evidence or the reports that come in from the government and evaluate them, and then see if we can't massage our version of the truth so that it's genuine and truthful, but works in my client's best interest. Because one of the few advantages you have as a defendant, especially if you didn't give a statement, is the government doesn't know what you're going to say at trial. So they don't have a transcript, they don't have you under oath, and you have the luxury of watching the whole case. And the way that I prepare cases, and I expect that it's probably similar for you, is I kind of work backwards. I look at every case that comes in as if it's going to trial, even though probably only 5 to 10% do, and start working backwards from there to see how we can get to the result we need to. So I look at every case as a trial case and then want to prepare it as such.
Yeah, I mean, 100%. That's also how we approach it. And you learn that through experience too, because the cases that you think aren't going to go sometimes end up going. And if you're not prepared for that from the beginning, you can find yourself flat-footed, I think. Absolutely. Another kind of common question that I get, and something that I think comes up with all the media hype around a lot of criminal cases, is the idea of defendants testifying at trial. Because, you're sitting around the dinner table with your family and there's a big case going on, and inevitably somebody says, well, if that guy or woman was innocent, why wouldn't they get up there and testify and tell their story and let the jury understand that they're not guilty? What do you say to that?
Yeah, I actually agree with them. And the reason I agree with them, and I don't think most defense attorneys do agree with me on this, but it's worked out pretty well for me. The only person I know that probably calls a defendant to the stand more often than I do is Mike Viscosi, who I think does it almost 100% of the time. I think I probably call my clients to the stand 80+% of the time. The reason being is I really I love trials, but I think the law doesn't matter at all. And I think that, the judge can instruct them genuinely and say, you can't hold it against this person. But almost everybody's sitting there and saying, if I was innocent and I could potentially face state prison, I'd get on the stand. And so one of my philosophies, and it's not really even just about the accused testifying, it's we got to find out what their strong things are. And the way it relates to testifying is, sometimes my clients have had criminal history, and that may come up if they testify, depending on the situation. So we look for the government's strong points, and then we try to steal them from them. So most of the time, if the client's here and they're with me, and let's say they have 3 prior convictions, and 2 of them they might be asked about at trial. Well, 9 times out of 10, those cases were ones where they pled guilty. So they admitted guilt to something they did. So I think you can, to a large extent, steal that from the government and say, listen, the last time he's not a perfect guy. You may not want to have him over to dinner, but the last time he was in trouble, he came in, he said, I'm guilty of that. He took his punishment, he served his time. And now he's here talking to you today and telling you, I didn't do this. And the fact that he was a bad guy 5 or 6 years ago, or made a bad decision, I wouldn't even say a bad guy necessarily, but the fact that he did something terrible 5 years ago doesn't mean he's a bad guy today. And he took accountability and he admitted that. I think you can actually make the person more relatable to the jury in that regard. I think some of the toughest cops to cross-examine are the ones who admit they screwed something up, even if it's a minor thing. I'm like, man, this guy is now endearing to the jury because they've all screwed something up. And almost all of us know somebody who's been convicted of something. And it doesn't mean they're a bad person. It just means they made a bad decision. I made a ton of bad decisions in my life. So I'm not going to, give judgment to somebody based on one thing they did, regardless of how terrible it was, if they have a track record of being a decent person.
Yeah, your comment about trials I actually had a conversation with another civil trial attorney just yesterday about this, and I think that juries are making assessments of witnesses and clients that have, are often very outside of what the legal arguments are, and it comes down more than anything, I think, to credibility and likability and believability. And I couldn't agree with you more about approaching, the potential pitfalls head on and just trying to get the client to acknowledge them. And because it's like you said, most people sitting there, people are forgiving if you're honest, but if they think you're lying to them, they will shut you down. In the civil world, that's what I see.
Oh yeah. Even if it's something minor, they think you're trying to, pull the wool over their eyes or something. You're done for the rest of the case, or at least that witness is. Yep. I remember the way that I came up kind of with that philosophy, and it's all, I expect the same for you. It's all kind of trial and error, and you see where you screw up and you see where you've got problems. I had a vehicular case where the lady was accused. She hit somebody and they died, and then somebody else was also injured. And I really, really liked this client. She was unbelievably charming, unbelievably accomplished, and the allegations were that she had done some cocaine, that she had smoked some weed, and she had a relatively high BAC. And she just couldn't wrap her head around doing any time or taking a felony. And it turns out she was right. I actually disagreed with her at the time, but she was in a very rural county. I shouldn't say small county, but rural county. And, you know, the biggest hurdle I saw wasn't the booze and it wasn't the weed, it was the cocaine, because people, you know, in that area probably hadn't had a lot of experiences with it, or maybe even seen it. You know, I've talked to a lot of people who've never even seen cocaine. So it was my position that I was going to say cocaine as many times as I could. It was almost like the word to take that out of the equation for the jury and show them that I was unafraid of the cocaine. And it turned out to be very, very good for her. I think it was a case of jury nullification. But they found her not guilty relatively short for a trial. And she had to admit on the stand, and this is a funny story, you'll appreciate this, that she had done cocaine. And so at the end of the case, we win. She's out. She's, you know, able to go on with her life. And she was a relatively young girl at the time, woman. Her employer, she had a good employer, fires her right away because it was in a lot of papers. So she ends up being hired by their competitor almost immediately and stealing all of their clients away from them. And she ended up making extra money because she admitted to doing cocaine, which was unbelievable. I was so happy to hear that, just because I was like, those guys, I was like, you get a not guilty verdict and then they fire you. Yeah, and she was as cool as a cucumber. She didn't care. And she was like, oh, I'll go to the competitor. They'll pay me more and I'll take their clients.
You used the term that, you know, I know, but an average listener might not. When you say jury nullification, what do you mean by that?
Well, this is one thing I wish people knew more about. You're not even allowed to talk about it anywhere other than, I think it's New Hampshire. It might be Maine. But we as attorneys can't tell the jury to disregard the law. But we know that they do. I won't say frequently, but from time to time, when they think a law is unjust or they think the punishment exceeds the crime, they'll ignore the law and deliver a not guilty verdict, even though by law, the person, according to the evidence, would be guilty. And that's the beautiful thing about our system. And I do wish we could talk about it, because the jurors have a ton of power in these cases, and nobody's ever going to go up and ask them or make them tell them why they delivered whatever verdict they delivered. Of course, unless it was illegal or they lied about something or, you know, perjured themselves or something during jury selection. So jury nullification is just basically the jury nullifies the law and delivers the verdict that they think should be delivered based on the facts, regardless of the law. And I know there's one state you can talk about it, but the rest of them, you can kind of suggest it, and I'm sure you've done that, but you can't really say it outright. And you want the jurors to know, like, listen, guys, the judge is telling you to follow the law. You do what you want to do, baby. You're the ultimate fact finders, and do what you want to do. And if you think it's wrong, then find them not guilty. I don't do many appeals at all. And there's two reasons for that. I'm not a great writer. And the second reason is, if I'm doing an appeal of my own case, I'm limiting some of their appealable issues, because, and I tell clients, fortunately, we don't lose a ton, but if they do lose, I want them to attack me. I want them to attack my work. I want them to attack the strategies we did. And if I'm doing the appeal, I may not go as hard at myself as maybe another lawyer will. If they can get the conviction overturned and it's my fault, I'm happy that happened. But I don't do many appeals.
Yeah. All right. So that brings up an interesting one, because, you know, a lot of times in criminal cases on appeal, you see these arguments about ineffective assistance of counsel, right? And in many cases, you know, I'm in the system, and I know a handful of good criminal defense lawyers, but there are many who I have no idea if they're good or not. But I'll see allegations of ineffective assistance against someone that I would perceive to have been a pretty good criminal defense lawyer. So you're saying you don't really care about that. It's just part of the strategy.
Yeah. I mean, what I care about, and I think we're required to care about, but I actually do, is the outcome for the client. And, if it's my fault, and even if it's not my fault, if they can blame it on me and say it was my fault, great. There was one time, speaking of ineffective assistance, I actually did do an appeal for a guy pro bono. I knew him growing up, and I liked him, and I believed he was innocent. And he had a god awful attorney. I mean, I'm certain that if you gave me $1 million and asked me to bet it on the case, I would have felt very comfortable putting it on the defense side. She just did a terrible, terrible job, and I appealed it. I actually got to argue it in front of the third department, strangely enough, at Albany Law School. And I thought I had a chance. Ineffective assistance of counsel is almost never, ever found, because, and I get it to a degree, because, it's easy to go back and be a Monday morning quarterback after trial and say, well, you should have done that. I do it myself. But in the moment, is the person doing the best they can? Do they have like some sort of strategy to make that happen? This woman, I did not think had one, but if you look at the case law, there was a lawyer who slept through the majority of a trial, and that wasn't seen to be ineffective assistance of counsel.
Amazing. It's amazing. What are some of the most common criminal cases that you work on in your practice?
I guess for me, and it may be different if you were a public defender, because, for me, I would say the most common is probably DWI. It used to be all I did when I worked for a firm. I never really wanted to just be DWI, but I'd still say it's probably 30% of our cases. And then you've got drug cases. And then it kind of is just random from there. I'd say DWI, then drug possession or drug sales. And then, it can be assault, it can be domestic stuff, it could be murder, it could be rape. I mean, there's a million different things. The reason I think DWIs are so popular with private counsel is, a lot of the times, and I don't mean to stereotype, but stereotypes or whatever, they're working people who have money to pay for an attorney. And a lot of times people are charged of some different crimes, may not qualify or may not have the ability to pay for private counsel. So I think that's really the reason. I don't know that it's the most charged crime, although I wouldn't be surprised if it is. But I think that's the reason for it. Normally they, I guess, at a higher rate would be able to pay a retainer fee.
Have you seen any noticeable decline in DWI cases coming in since the Lyft and Uber and rideshare services have increased around our area?
Yeah, I think so. I don't think it's dramatic, although I could probably pull up numbers and tell you. But yeah, I think so. And frankly, in an area that has those services, people should be doing that. I get it. I'm not going to say I've never drank and drove. I have. I don't do it now, but the best made plans sometimes go awry, and then all of a sudden you're behind the wheel. And again, not a good choice, but good people make bad decisions. And the problem is sometimes people think they're fine to drive, and maybe they even are when they get in the car and the alcohol is still absorbing into their system. And you're asking a drunk person theoretically to make a decision on what their capabilities are. And I don't know about you, when I get hammered, sometimes I think I can do a lot of things that I really can't do very well.
Yeah, I suppose when you look at it that way, it's they're not making the best decisions, not in the position to. Which actually brings up another question that I get often, which is, people always ask, and they ask me, and I don't know what the answer is. If I get pulled over and I've had a couple of drinks, what do I do? Do I blow into the breathalyzer? Do I refuse it? If I refuse it, is my license going to get suspended? If I, what's the sort of general consensus or your general philosophy, understanding that we have a big disclaimer on this whole podcast that this is not legal advice. This is just us talking for the purpose of discussion.
Oh yeah. I mean, and if I knew nothing else about the case, I'd say don't blow. Like, I have no other details. You call me up and you say, I got to make this decision in 2 seconds. Am I blowing or am I not blowing? I say no. But it becomes way more nuanced than that if you can get some additional information from the person. And you have to be careful about how you do it because they're typically sitting in custody around police officers. So what I try to do, if I'm in that situation, is I try to ask them yes and no questions so that, the police officers can't really use what they're hearing or whatever from me, because it's normally not a private conversation. It's a private conversation, but they can hear, I guess, my clients' or potential clients' responses. So, one of the things you got to find out is what they do for work. If it's a CDL, it creates all new issues because it's a lower threshold for a DWI. Those people, their license is more important to them than most people. And then you have to find out, have they had any prior DWIs? Because if they've had prior DWIs, the criminal case is probably going to be more important than the license itself. You have to find out if they got in an accident and if anybody was injured, because again, if that's the case, then the criminal case is going to be more important than anything else. And then if it's just a run of the mill or a regular DWI, you have to ask the person or try to figure out how many drinks the person had, how high they're going to be. And if you're well versed in that area, like my advice differs if you're in Albany County versus Saratoga County versus Schoharie County versus Delaware County or something like that. Each county has a different way of handling those cases. So if you know the county that the person is calling from, you may, like, for example, there are some counties, and I don't want to call any of them out because I don't want them to change their policies, but there are some counties, if they have a refusal, you almost always get an AI, which is great for the client 90% of the time. But there are some counties, for example, Albany, if you have a refusal, they won't offer a reduction. So you're trying to figure things out there. And it does have some dramatic license consequences that people should be aware of as well, because if you refuse to blow, you're entitled to a hearing through DMV, but that has changed dramatically since I've been doing this. I think we used to win probably 20 to 25% of those cases. It's probably less than 10% now. The DMV, the scumbags that they are, have put in a bunch of people who just find for the department every single time. There used to be some really good judges there, but now they just insert people who are going to find for them. There's almost no real appeal mechanism. You don't ever see a real judge. I think it goes to some intern who's sitting in a basement. They rubber stamp it. I've never seen a DMV appeal win outside of real court. And then, so you're probably going to lose your license. And what most people don't understand is if you lose your license after a refusal, the only way to get a conditional license, which sounds so stupid, is to plead to something alcohol related. So you could lose the refusal hearing, win your case, get it dismissed, and you'd have no license for a year. But if you pled to a DWAI, you'd have a conditional license the entire time through the year. It's such a corrupt way of doing it, and it forces people into pleas that they shouldn't take. It forces people to make a decision, of choosing their livelihood over an adequate criminal defense. So it's very, very nuanced, but knowing nothing else, I lean on the side of not having people blow. I know some attorneys disagree with me on that, but I think anytime you have a chance to not give the government evidence against yourself, you don't do that.
Yeah, that makes perfect sense. It's interesting though. I mean, the way you're talking about it, if you're in certain counties, Albany that you use as an example, I mean, if you have 2 drinks and you refuse, they will not plea that out. You're either taking a full DWI or you're going to trial.
Yeah, most of the time. And I don't want to pat myself on the back here, but they know I'll go to trial. And I think of all the cases I've ever done with DWI trials, which is probably towards the 100 mark, I've never had, no, that's not true. There is one time, all of them but one where there was a refusal. Nobody's ever been convicted of a DWI. Wow. Not ever. And the only reason the girl that I had was convicted of a DWI. It was a weird situation where she was charged with a DWI and also not having her license, which made it a felony on that regard. So we had to go for broke on that and try to win it without giving the jury the kind of incentive to compromise and go to a DWAI. So we had to go for broke, and I really went all out on it. And ultimately she was convicted of both the DWI and the aggravated unlicensed operator in the first degree. But the reason for that is the aggravated unlicensed operator in the first degree, even if you're impaired, you're guilty. And that's what we were trying to beat there. So I didn't really ask for or try to get the impaired there. But of all the cases where an impaired works, and an impaired is a beautiful thing because most of my DWI trials will be felony trials. It goes from a felony down to a traffic infraction if you get the impaired.
Okay, so it's not even a misdemeanor at that point.
Most of the time, not. There are some scenarios, like if you had, I think, 2 DWAIs or 2 prior alcohol convictions in the last 10 years, an AI might be a misdemeanor. But the vast majority of the time, an AI is going to be a traffic infraction, punishable by either 15 or 30 days in jail maximum. And most of the time you won't get that. You know, I had one case where that's exactly what we got after trial. And the prosecutor asked for jail time, and the judge was like, are you crazy? He's like, I'm surprised you're even asking for a fine. You did such a terrible job with this case, and you were so brutal in the way that you went after this woman in a way that wasn't right. And the jury, that's the way it'll happen if you end up, getting an AI. The judge knows that that's a win, and he or she is not going to put your client in jail for 15 or 30 days, which is just enough to lose your job.
Yeah, you bring up a point that probably most people don't really know or have reason to know. But as I understand it, in federal practice and federal crimes, there are often mandatory sentencing guidelines. My understanding is that's not typically the case in state court proceedings. Is that accurate? And if it's not accurate, or even if it is, how do county court judges or the everyday criminal judge, how do they determine sentencing and that kind of things in the event of a conviction or a plea?
Well, that's a great issue to discuss because it's strange. It's one of the reasons why I actually like criminal defense in state court better than the federal side of things. The federal side of things, yeah, you're right. Almost all the crimes have a mandatory minimum, and they also have the guidelines. And then you've got the U.S. Attorney's Office, who normally will just basically offer you to plead to what you're charged with, and then you can kind of help yourself through cooperation or through taking accountability or whatever the things are. I mean, I don't like the lack of discretion in federal court, especially for judges who are appointed for life. So therefore, they would be someone who could be fair and evaluate the circumstances without having to worry about running for election or what the public necessarily thinks, because you want a judge that's looking at the case and not, the outside implications of it. In state court, there are some crimes, and it's primarily felonies, that have mandatory prison sentences. It's mostly, I think, A, B, and C felonies. I think D and E, unless there's a prior, there are no mandatory minimums. And it could be settled with just the fine and a surcharge, probation, local jail, state prison, whatever. There's only one misdemeanor I can think of with something like that, although I'm sure there are others. And that's the aggravated unlicensed in the second degree. It's a strange one. It requires either a probationary sentence or a small amount of jail. And I'm forgetting what amount of jail. It's like 30 days or something like that, regardless. So I don't know that I've ever had a client plead to one of those, but that's one of the rare situations. And normally, you have judges who have a wide degree of discretion. And it's another thing, and I'm sure you deal with this too on the civil side of things, which, is a different ballgame, but kind of the same. You have to know the judges you're in front of. And if you don't know the judges you're in front of, you better talk to somebody who's there locally. I mean, I can try a case anywhere in the state, but I should still have a pretty good idea of what that judge's tendencies are, where their leanings are, and things like that. Because there are some judges, that are very punitive if you're convicted in their court. And those are, to a certain extent, easy to advise your client. Listen, if you get convicted in front of Judge Breslin, you're going to get a year or two less than the max, most likely, whatever that is. If you get convicted in front of, this guy, it's more of a toss-up because they may give you less than what your offer was. I've had some trials where, a client was convicted and they did better after trial than what the offer was before trial. And those are good judges. Those are the judges you want to be in front of, but they're much more difficult to advise your client on because, we do have a lot of really good judges. And I actually even like Judge Breslin, even though he's more punitive than I would agree with. But you've got to think, well, this judge could go anywhere on that. So it's a much harder decision. There are some judges, that I'm thinking of right now that, if they get to know your client through a trial, they're going to be way better about it because they're going to see him as a person. And then there are some judges who so don't want trials, and they shouldn't be judges, that they just blast people after trial. The entire town of Colony is like that. I mean, I shouldn't say that. There's a new judge, but Judge Masry, Judge Crummy, and Judge Summers were all like that. You do a trial in there, you could win on a DWI and get a DWAI that was never offered, and they try to put you in jail for 15 days with no other record. I mean, the county court judges in Albany were awesome, and they would get rid of those. They get the guy out immediately, but that would still cause them to spend a night in jail for, in essence, winning their trial.
Wow. Yeah, it's interesting, and I don't think people on the outside have any idea of how that system works. And your point about how it should almost be reversed in terms of having these guidelines at the level where people are running for reelection makes a lot of sense. It's something that I could talk about for a long time, and maybe some other time. But I remember listening to a podcast, I think maybe earlier this year, that it was maybe a serial podcast or something like that went into, it did like an investigation into a judge. I want to say it was in Chicago or in some city that was, sort of being unbelievably abusive to like certain demographics of defendants.
I think I heard that one.
And it was,
it was either Chicago or Cleveland, I think.
Yeah.
I'm not sure which one.
And it was
one of those Midwest cities.
Yeah. It's like, it's frightening if you don't have, that goes to a sort of a bigger conversation, which I'm not sure we have time to get into today, but about if you don't have the resources to get somebody good or somebody, frankly, who's not completely overworked, which I imagine most public defenders are, who can really, protect your interests. And I would imagine that's something you see in terms of, those people in those positions who have these super high volumes of clients coming in and out every day, and they're just, please become almost completely necessary, because otherwise the system would shut down and it's impossible to prepare all those cases for trial at the same time, right?
Yeah, no, you're 100% right. And I have this weird fantasy that everybody just takes their case to trial, and then we stop getting so many bullshit cases in the criminal system. But the problem is that you have to serve your client. You can't fight the system through your client, and you have to do what's best for them, and you have to let them know what's going on. But there are some great public defenders. Bo Melita and Don Pardick are two of my favorites here in Albany. And there were some great ones down in Ulster County when I was the prosecutor. And it was funny because you would occasionally see a client fire them to go get a worse private attorney, which was crazy to me. I was like, man, you were doing it so wrong. But the problem is, and I agree with you on that, is like resources are important. Like if you have enough money, I really do think you could beat almost any case that has ever been there. But the problem is you've got, again, the attorney advertising, which we talked about earlier, which misleads people, in my opinion. And then you've got, people who just can't afford the representation that they deserve or need. And I feel bad for my clients, especially the ones who come in and who are innocent. I said, you're going to pay me a boatload of money, and your best case scenario is, I'll just use, for example, say it's a $15,000 case. Your best case scenario is you go home and you've paid me $15,000 that you never get back. Like, that's your best case scenario. You're not getting it back. Nobody's going to write you an apology letter. Nobody's going to say, we got this wrong. Unless there was a real abuse of power or something unethical done, you're not going to be able to sue for it. The state's not going to reimburse you for your medical or for your legal fees, even though you were exonerated. It's a crazy system that your best case scenario as a criminal defendant is to pay an attorney a bunch of money that you'll never get back and hope that you win.
Yeah, I would imagine that's one of the bigger challenges that people are facing in that scenario. I want to ask about another challenge for you, and I imagine for anyone who is in that sort of position of potentially having anything that's a case that's high profile or in the news. How do you deal with the explosion of social media and stories and gossip and all the kind of scuttlebutt that goes around any kind of reasonably high profile criminal case? I imagine the jury is supposed to be impartial, right? And you mentioned earlier on, right in the beginning, that when your client walks into a courtroom, everybody already thinks he or she is guilty. So how is that a problem? Do you see it getting worse, and how do you deal with it?
Yeah, it is a problem, but we as attorneys, we have to adjust to that and figure out ways to do that. And I think we've done it. It's both a problem and a solution, though, because normally if it's any sort of case that's serious and I'm worried about them getting on my client's, Facebook or Instagram or whatever the case it may be, we shut it down, and I'm like, you can't have it. And maybe they've already got it. Maybe they got it through screenshots. Maybe they got it through somebody sending them something, but we take it down as quickly as we can. But then we're able to investigate some of the witnesses, and some of them will be public. And we often get great information about that client, or not the client, about that witness that we can then use at trial. So, from a defense standpoint, it's great. Like, going back to the jury, I assume they're reading the paper, and I assume they're looking online at things, even though the judge tells them, orders them not to, and they could get in trouble if they were caught doing that. So one of the things, and I tell my clients, it's your choice, but it is my intention when the media calls or asks for an interview, it is my intention to do that and paint you in the best possible light I can, because at least one or two of the jurors is probably going to read the paper, and it's probably more like 7 or 8. And if we say no comment, or if we're not painting you in the best light possible, there's going to be an article that only talks about you negatively. To be very fair, and I'm certainly aware of this, me doing interviews and talking in a paper certainly helps my business too. So I have to be cognizant and make sure that I'm doing it for the client and not for myself. But most of the time, I think answering questions and putting your version out there is going to give you a better chance, not a worse chance. I won't get into details. I'll just, probably similar to most people who talk, I'm going to, use little cliches and catchphrases and things like that to make them look better, but I'm not going to lay out my defense. I'm not going to tell the prosecutor what I'm planning on doing, but I'm going to paint my client as best I can, so that if even one person is reading it, or even if it's a juror's husband who's like, oh, well, I saw on the news that this guy's doing that, I want it to have something good about my client.
Yeah, well, I think your point's completely right. If you don't do anything, then the other side can control the narrative before it ever gets there. And I think it's somewhat unrealistic to say that a jury is going to sit in a trial and not, with smartphones, not walk out the courtroom and Google something. Maybe some of them will abide by that. It's just hard to imagine that all of them are. So I think your approach sounds like very reasonable.
Especially longer trials. I mean, I don't know how long like an average trial for you goes, but like if you think about it, like people are pretty obsessed with themselves to a degree. So like if there's something that they're involved in that's going to be in the paper, myself included, I'll read the articles or whatever, just to, I say that I'm doing it because I want to see what everything's putting out there, but I also want to see how I look and how the client looks in the paper as well. So I got done with a 6-week trial this summer. Like the idea that the jurors didn't hear anything about the trial while it was going on, it's crazy to me.
Yeah, we're not anywhere. I mean, for us, a long trial is 2 weeks. I actually can't even imagine a 6-week trial. I just know, you and I are probably similar in that the lead up to the trial for me is always the most challenging part because there are so many moving parts and it's unbelievably stressful because of all the things that you're thinking about. And then you get into a courtroom, and whereas most people find that to be intimidating, to me, it's like, okay, now I'm here. Now I'm doing what I want to be. I want to be trying a case and in front of the jury and talking to them. And but I also know that it's all consuming. And so for me, when I'm on trial, it's like everything else just goes by the wayside in terms of, it's hard to maintain balance, I think, when you're on trial. So for 6 weeks, that's impressive because,
mine are typically more like yours. It's normally between a week and 2 weeks.
Yeah.
That was the longest one I've ever done. But, and I have a very similar thought process to you. The two parts of the trial I hate the most are the build up to it and then waiting for the jury, because you're not really in control at that point. And I tell my clients this all the time, because trials are expensive. And I say, I'm doing the trial for free. You're paying me to prepare for it. And it's kind of like that old Ray Rice quote. He said he played Sundays for free. The Ravens were paying him for Monday through Saturday.
Yeah. Yeah, that's exactly right.
And I think that's right on point, because as I've gotten older, it's even worse. I hate preparing even more because I know how vital it is, more so than when I was younger. And the clients get a little thrown off by that. I'd be interested to hear how you prepare, but like I'm a slow burn initially. If the client comes in, and I tell them this is not a secret, but I said I pay very little attention to the details until we have to start paying attention to the details, because I don't want to burn out on this case before it's time to burn out on this case. So like the 6-week trial was tough because you couldn't prepare for it all beforehand. And there were going to be a bunch of things that you didn't know. And to be fair, we did have Wednesdays off and weekends off. So you had a little bit of time to do other stuff, but that was the toughest one to figure out how to prepare for, because if I prepared for it like I would a 1 or a 2 week trial, I would have jumped off a bridge or something. Like there's no chance that I would have been able to go for the full 6 weeks.
Yeah. At that point, I think you have to change your mindset somewhat. And I think you're like me. You're a CrossFit guy, right? You're into, yeah. So for me, working out is like I always call it like my antidepressant. It's what keeps me in balance, and especially in this job because it's so stressful. So I find myself when I'm in the middle of trial getting up at like 4:30 or 5 in the morning, so like just to get a workout in, so that I can be balanced when you're dealing with all the ins and outs of the trial. So that's good for the short term, but for me, I don't know that it could be a full.
It's funny that you say that, because during again the 6-week trial, I was talking to both the prosecutors, and they weren't doing anything other than preparing. And I said, that to me, like waking up and going to the gym in the morning is absolutely mandatory for my sanity and frankly for doing a good job at the trial. So I'm glad you brought that up, because like that's the one place I don't bring my phone in, or I might bring it in just to listen to music or something, but I don't answer it. I don't respond to texts. I'm not looking at things. And it's the one place where you can burn off some of that nervous energy. And I agree with you completely. It's an antidepressant for sure. And it also gets rid of some of the anxiety, and you're just feeling better. But this prosecutor, and I liked him a lot. And I enjoyed working with him, but he wasn't eating. He wasn't working out. I mean, he almost passed out in the middle of trial. And I'm like, Al, dude, you got to take care of yourself, brother. I was like, the trial's important. I get it, but like, you can't be passing out in the middle of goddamn court.
No, I mean, if nothing else, it doesn't look great in front of a jury, So yeah, you gotta, it's like you said. I mean, and I think I said it too. I think the juries are they pay attention to things that you're not necessarily thinking about. And I think if you're in a courtroom and you have energy and you appear sharp, like you're on top of things and you're there and you're engaged, I think that plays a big role in how they ultimately think of you in terms of your credibility and everything else. So yeah, I'm with you. I'm with you on that one. All right. Just a couple more questions and I'll wrap up. I want to be respectful of your time. What are you, I've asked you about a few sort of common questions that I get. What kind of common questions do you get from people who when they hear that you practice criminal
law? Most of the questions are like, the biggest one, and you hit it, was whether or not you should blow. And like I said, that's nuanced. The other one that I always tell anybody who will listen, and it's not even always asked all that much, but this is actual advice that I think holds true regardless of the details. Don't talk to the police. Like, if they come and they knock on their door and they say, "We have a few questions for you, Scott," don't do it. Like, I know I mentioned him once before. My buddy, Mike Viscosi, actually was talking to a bunch of high school kids at Schoharie County Court with the prosecutor and the judge. And he said that to him, and everybody kind of laughed and stuff. And he was like, no, don't talk to him. He's like, you don't get a Best Buy gift card at the end of the conversation. He was like, you don't get anything. And it's always been my opinion. If you're guilty, you don't talk to him. If you're innocent, you don't talk to him. If you're somewhere in between, you don't talk to him. You call a lawyer if you know you're being investigated. Obviously, if you're reporting a crime or your car was stolen or something, of course talk to him. And this is not an anti-police statement. I have a lot of friends who are police, but there's absolutely no reason to talk to them without consulting a lawyer. They tell you right in their warning. They say anything you say can and will be used against you. And that means anything. If you tell them something that's true, they're going to use it. If you tell them something that's a lie, they're going to prove it's a lie and you're a liar. And if you get a detail wrong, even mistakenly, you then become a liar. So there's no reason that you should ever go and talk to the police on your own behalf. Even with me, it's almost never something where I'll even go in and talk to them with my client. I mentioned this earlier, but the less they know about what you're going to say and what your defense is, the better it is for you. And that's whether you're innocent or guilty or whatever. So I'm not interested in providing those details. The cops are trained in getting people to make admissions to things that they did and even things they didn't do. There's a million false confessions. You were talking about listening to podcasts. I've listened to several from people who are involved in the Innocence Project, and oftentimes they come with confessions because the person either gets tired or that another thing, and I'm jumping around a little bit here, is people don't know that the cops are allowed to lie to them. They're allowed to say, we have you on camera coming out of that car and we saw that you had a white powdery substance in your hand, and they don't have a video, they don't have a camera, they don't have anything, and the person's like, oh they got me. So there's no reason to do that because you don't know what you're doing. And I've never seen somebody walk into a police station in handcuffs and talk their way out of being charged. It just doesn't happen. And the scariest ones are when the person is not being charged and they ask you to come in and talk. And most people are good people, especially if you haven't been charged before. They're like, oh, the cops are good guys. And they are. Again, not an anti-cop statement. But they've got a job to do. And sometimes when you're a hammer, everything starts to look like a nail. So, the best thing you can do is call an attorney. And if the attorney tells you to talk to them, call a different attorney. And then if you can't afford or don't want to pay to an attorney, just tell them I'm not answering questions without an attorney.
Yeah. I think a lot of the times people, they get this statement, will be easier on you if you cooperate. And there's a bit of a deferential or intimidation factor where they think, this will go easier if I just cooperate, if I just talk to them. And I would imagine I get this in the civil world where clients come to me after they've already done or said something that they shouldn't, because they thought, and this is a famous line, I thought I could just handle it myself. And it can be pretty devastating in my line of work, and I'm sure it can be really devastating in your line of work. And it never ceases to amaze me. And I tell people the same thing. If any investigator of any kind calls you, they expect that you're going to call a lawyer. They're certainly happy if you don't and you talk to them, but you're not going to offend them if you tell them you want to talk to your lawyer. That's part of the process, and they know that, but you don't know that, right? And that's the problem.
Yeah, and it's just it's heartbreaking, because you will have those situations where the cops like, just tell us what happened and you can go home. And you watch it, because oftentimes they're videoed, and you're like, don't say it. Like, you're not going home, buddy. There is no chance. And I'm like, oh, please don't say it. And it just breaks your heart, because a lot of times it's young people, and a lot of times it's just people who have never been involved in the system. The easiest clients to defend are clients who've been through it, a handful of times, because they know what's up there. They know more than some attorneys who practice in the area. And so they're smart enough and savvy enough to know how to handle themselves. But most of them are just so gullible, and they want to believe whatever is being said to them, and they walk themselves into a conviction.
Yep. Right when I came out of law school, you know how it is when you first become a lawyer, all your friends are calling you with questions, and all these people that as soon as they hear you're a lawyer, they start calling you with everything. And I can remember a number of times where younger brothers of friends, or cousins or family members, it was a lot of times kids who are 17, 18, 19 years old, and maybe they've got some marijuana in the car or something, and it was always, I thought it'd be easier. They said if I just cooperated, it wouldn't be a problem.
Yeah.
So
and I get that. I mean, I could have made that same mistake for sure.
Yeah.
It's
right.
it's funny. Go ahead.
No, go ahead.
It's funny because I always tell this story. It's probably, it was when my wife was pregnant with our second kid, and the FBI came to our house, and they were coming to investigate something with regard to taxes with a accountant we had used, but it had nothing to do with us, really. We weren't in trouble, but my wife was, sleep deprived and has a baby upstairs sleeping, and she, I don't know how often pregnant she was. And the guys were like, well, we just need to come in and talk to you. And she's like, my husband's an attorney, just call him. And they were like, no, we want to talk to you. It's a couple things. And she just slammed the door in their face. And I was like, you're a G. I was like, I'm not even sure I could do that. And I know that that's the right move. And she was like, she's like, I'm not sure I would have done it if I wasn't like 7 months pregnant with a sleeping baby upstairs. But she was like, it was beautiful. And I was like, I'm so proud of you. I was like, that's the move.
That's a pretty badass move, especially with the FBI. That's I'm sure most people would be like, all right, fine. Yeah.
I would have been like, come on in, have a cup of coffee. You guys are the FBI.
All right. Well, this has been really interesting. It's been a good conversation. I really appreciate you coming on. We'll have to do this again if you're open to it, because there's lots. I had a lot of notes about some criminal cases. There's always stuff in the news, and I think your perspective is really, really interesting and helpful.
Well, I really appreciate you having me on, and I certainly am always interested in learning more about the civil side of things. And I love the fact that these podcasts exist now, because a lot of times, like when I was a younger guy, I didn't want to talk about any of the things I did because I thought it was some sort of proprietary thing, and I knew better than other people. But now I just want people to know what their options are and where they can go and who they can go to. And if they hire me, great. If they don't hire me, hire a good attorney, use your rights, explore different options, talk to different people, and things like this podcast and many others are really a great resource for people. So thank you.
Yeah. And on that note, where can people find you if they're looking to, hopefully they don't, it's like, people always say this to me, hopefully I don't need you, but if I do, where can I find you? So where can they find you?
Yeah. Our website is OE. So O'Brien and Eggleston, OE-legaldefense.com. My email address is kevin@OE-legaldefense.com. legaldefense.com. And frankly, I give everybody my cell phone because I want them to be able to get a hold of me. So my cell phone is 518-618-5423. And I'm happy to answer questions and even point you in the right direction if it's not something that I do or would be comfortable doing. So I just want people to know what their rights are and be protected, because, whether it's a civil case or a criminal case or whatever, there are people with more resources and motivations different than yours that can really hurt you financially, put you in jail, whatever the case may be, take away your children, whatever it may be. So, a more informed populace is a better populace.
Yeah, I couldn't agree more. So I would encourage anybody listening to this who has a problem to call Kevin before talking to anyone else.
Yeah, please do.
All right, with that, we'll wrap it up. Kevin, hopefully we'll talk again soon on the show, but thanks again.
Anytime, Scott. Thank you.